like the dummy number.
Yeah, Usha, over to you.
Okay. Greetings to all the respected members of the bench. Welcome to the final round of our National Moot Court Competition 2024, jointly organized by the Sambhav Initiative and Pro Bono India in association with SMP Majmudar Associates on 23rd and 24th of November 2024. After 3 rounds of intense competition, we have our two best teams ready to present their arguments before you. These teams have shown excellent skills in understanding facts, using case laws, and presenting their arguments clearly. Each team will have 50 minutes to present their case, including rebuttals and surrebuttals. However, extension of time duration is subject to the sole discretion of the bench. We are especially thankful to have such experienced judges with us today. Your presence marks this final round more meaningful for our participants who will greatly benefit from your observations and guidance. To our finalists, this is your moment to show everything you have learned. We look forward to witnessing compelling arguments, legal reasoning, and professional court etiquettes from our finalists. All the very best. Thank you.
Okay.
Sir, should we begin?
Yes, please.
The council seeks permission to approach the dais.
Yes, please.
Much obliged. The council seeks permission to address the bench collectively as your lordship and individually as your lordship.
Okay. Yes, please.
Much obliged, your lordships. Your lordship, counsel number 1, along with co-counsel and researcher, are representing the petitioners in the case of Sarvesh Kumar and others versus State of India and others. Your lordship, the council seeks permission to move on with the facts of the case.
Yes, please.
Yes.
Much obliged. Your lordship, on 10th April, the local leader was arrested who was accused of embezzlement, and leading to this, a protest had broken out. The state government had invocated Section 144 of CRPC, imposing a curfew and authorizing the police to use the force required to restore order. Your lordship, during this unrest, Inspector General Rakesh Singh had carried out a series of encounter operations that was aimed at what they described as armed and dangerous criminals. Your lordship, during the encounters, 5 innocent young men were killed who the police claimed that they were leading violent mobs. But your lordship's eyewitnesses and local activists have stated that these men were innocent, unarmed, and were shot in cold blood. Your lordship, Sarvesh Kumar, a local activist, along with the families of the deceased, has filed this instant writ petition before your honorable bench. If your lordships are satisfied with the facts of the case, the council seeks permission to move on with the time division.
Yes, please.
Much obliged, your lordship. Your lordship, council number 1 will be dealing with issues 1 and 2 within 20 minutes, and council number 2 will be dealing with issues 3, 4, and 5 within 20 minutes. If your lordships are satisfied with the time division, the council seeks permission to move on with the issue.
Yes.
Much obliged, your lordship. Your lordship, the first issue deals with whether the encounter killings by the police had violated the fundamental rights of the deceased under Article 14, 19, and 21. Your lordship, it is
But
Yes,
you are
sir.
proceeding on the basis that the police officers have admitted that these are encounters. The police officer's case is that these 5 persons were indulging into very severe and dangerous armed and dangerous activities as criminals, and the police officers had to take action in self-defense. The police officers have not admitted that these were encounters. Encounters,
lordship.
we know that encounters means the fake encounters, you know. The police
Yes.
officers have said that this they had to do in self-defense. So what do you say about that before you go to the constitutional debate?
Yes, your lordship. Your lordship, it is most humbly submitted that the state had authorized the police to use force. Your lordship, nowhere the state had defined the definition of force to be used by the police. But your lordship, force has been defined under section 349 of IPC, which states bodily harm. Your lordship, the police at their discretion had taken the definition of force and started encounter operations that was aimed at neutralizing what they have described as criminals. Your lordship, in the present case, the police had restricted the rights of the deceased people by killing them and taking away their right to life, their right to be informed of their crimes, and also, Your Lordship, they were not given a chance to be heard fairly before your court. Your Lordship, it is also humbly submitted that these police officers' action had led to serious detrimental effect to the public at large.
But the
Mhm.
query probably you did not get. The query is that why do you say that it's an encounter? How? What's the evidence? What's your submission on that?
Your Lordship, in the facts, it is clearly stated that the police, under the leadership of our Inspector General Rakesh Singh, had carried out a series of encounter operations. These police officers had encountered these 5 men who were innocent and unarmed and were just exercising their right under Article 1913, Your Lordship, 19(1)(b), Your Lordships.
They, according to them, they have to neutralize these armed and dangerous criminals.
Yes, Your Lordship. But Your Lordship, the definition of armed and dangerous criminals is what they have described them as. There is no judicial proceedings, no evidence that has stated that these 5 men were included in the protests.
No, but like at that point of time, what could the officers have done? Could they have not acted in self-defense?
Your Lordship, it is humbly submitted that under Section 129 of CRPC, the provision speaks about dispersal of unlawful assembly. Your Lordship, it is stated in the section itself that on commanding the assembly to disperse, if the assembly shows that they will not be dispersing, only then the police could use civil forces. Your Lordship, there were other resources that the police could have used in before taking the measure of encounter. There is they could have used in force in the terms of tear gases, lathi charge, but they directly had to jump to the extreme measure of taking someone's life.
Okay. Yes, please continue.
Much obliged, Your Lordship. Your Lordship, the first issue deals with violation of Article 14, 1921, and it was submitted that it was grossly violated by the actions of the police leading to the encounter killings. Your Lordship, the same would be submitted in a threefold manner. Your Lordship, Article 14 talks about equality before law and equal protection of law. And in the case of E.P. Royappa versus State of Tamil Nadu, 1947, 4 SCP 538, the concept of arbitrariness was brought in.
1974. You mean 1974, not 1947, no?
1974, Your Lordship.
Yes. Okay. Yes, please continue.
Your
We
Lordship,
heard you saying 1947.
You
That's why.
said 47 and you
Yeah, that's why.
I apologize, Your
Okay,
Lordship.
yes. Okay.
Your Lordship, it was stated in the case that where an act is arbitrary, it is implicit that it is unequal. Your Lordship, the same is thus held to be violative of Article 14. It is also humbly submitted that in the present case, when Section 144 was invoked, Your Lordship, the procedure under Section 144 was invoked in such a manner that it caused more chaos to the public. Carrying out encounter killings not only took public's trust away from the law enforcement, but also from the state authorities. It is also humbly submitted before Your Lordship that in the case of A.K. Kairapak versus Union of India, AIR 1970 SP 150, it was stated that natural justice, which consists of rule against bias and right to fair hearing, is an integral part of Article 14.
That
Your
that
Lordship,
case was about interview for recruitment for
Yes,
some
Your
selection
Lordship.
process. How would you apply that case to the facts of this case?
Yes, Your Lordship. Your Lordship,
A.K.
the
Karapak,
case.
no? A.K. Karapak is a very
Yes.
well-known case for the principles of natural justice.
Yes,
That
Your
a person
Lordship.
cannot be a judge in his own cause. That
Yes,
is the
Your
principle
Lordship.
for which the case is known. Yes.
Your
So how
Lordship, in
would it
the
apply to this case? This is
Yes, Your
this is not a
Lordship.
case regarding a selection process where a member of selection committee is known to some other person or there is a bias or anything of the kind.
Yes, Your Lordship. It is humbly submitted that in the case of A.K. Kairapak versus Union of India, the selection committee has caused. The question was raised whether it was quasi-judicial function or administration function. Your Lordship, it is humbly submitted that the principle of natural justice and fair hearing was brought in this case, which is very relevant to the present case because, Your Lordship, the deceased people, they never had a
But
chance to
how
be
does
heard.
this, I'm sorry to interrupt
Yes,
you,
Your
but how
Lordship.
does this judgment apply in the facts of present case? Whether natural justice is to be applied when a person's life is at threat? if he's defending himself, should he hear the other side before he shoots him?
Your Lordship, it is humbly submitted that in the rule of natural justice gives the citizens a right to be heard before your honorable bench. Your Lordship, in the present case, this was not given to the people who were killed during the encounter. During the encounter, the police had taken the discretion and decided that these people are criminals, they are dangerous people who are leading the mobs, and hence they had taken the decision of encountering these people without giving them a chance to be heard before your lordships.
The earlier judgment which you cited of 1974, have
Yes,
you
your
checked
lordship.
whether that has been followed subsequently or whether it has been overruled? Or have you checked the position of precedent?
Yes, your lordship. The judgment of E.P. Royappa versus State of Tamil Nadu is still valid, in which the senior bureaucrat had challenged his transfer orders.
Are there any
Yeah.
guidelines which a police should follow in such cases? Are you aware of any precedent on this?
Yes, your lordship. Your lordship, in the case of PUCL versus State of Maharashtra, the guidelines, the Supreme Court had given a 16-point guidelines to be followed when an encounter is to be taken place. Your lordship, the citation of the case is 2014 10 SC SEC 635, in which a 16-point guidelines had been stated, which was not followed in the present case, your lordship.
Okay.
The council seeks
Yes.
permission to move further.
Yes, please.
Much obliged.
Can you point out which guidelines are not followed in this case?
Exactly.
Yes, your lordship. Your lordship, in the case of PUCL versus State of Maharashtra, the 16-point guideline starts by saying that when the police officer has the intelligence or a tip-off regarding any criminal activity, he should note it down in writing in a diary and register it first. Then, if during this tip-off an encounter has taken place by the police officer using firearms, then the death of that needs to be registered under an FIR under section 157 of the code. Your lordship, these provisions itself have not been followed even after, and the third point says that an independent investigation agency needs to be set up in order to look into such cases. Your lordship, in the present case, it is humbly submitted that none of these guidelines were followed. The council seeks permission to proceed further if your lordship are satisfied with the.
You are referring to the guidelines after the event takes place.
Exactly.
Are there any guidelines regarding the event?
Your
How the
lordship-
police should act?
Yes, your lordship. Your lordship, the first point of the guideline itself states that when the police receives the information of any criminal activities that are going on, or if they have a tip-off of the certain activities to be taken place, they are supposed to write it down in the diary in a written format and present it before a senior officer. This, your lordship, had not taken place in the present situation.
Are you aware of any Supreme Court judgment of the Supreme Court of India, where the Supreme Court has laid down the guidelines for arresting a person?
Yes,
Okay.
your lordship, in the case of DK Basu, the
Okay.
guidelines for arresting was provided.
Okay, all right. Do you think that the facts of that case, the principles in that case were violated? Because here there were this 5 youth who, according to the police, were indulging in some violent activities.
Your lordship, according to the facts of the case, these 5 men were not present at the protest, your lordship. These 5 men were stand-byers who had been encountered by the police because they claim that these people were leading the violent mobs. But your lordship, there is presence of eyewitnesses and local activists who say that they were innocent, unarmed, and they were shot dead, your lordship.
But will we be able to give any findings and grant any reliefs without examining the witnesses, whether we should do it in a petition under Article 32 of the Constitution? In a
Your
petition
lordship-
under Article 32 of the Constitution, we can certainly examine any challenge to the violation of a fundamental right. But can we go into the questions of fact, or will it require some other preliminary steps to be taken before we proceed with the hearing?
Your Lordship, it is humbly submitted that the Supreme Court is a court of law. But Your Lordship, in this present case, it is also pertinent to listen to both sides of the case before deciding, Your Lordship. Your Lordship, in this present case, the police had not taken any inquiry after the encounters had taken place as they were supposed to, where the witnesses were to be examined.
Okay.
Then why did you come under Article 32 straight away? Why not Article 226?
Your Lordship, it is humbly submitted that in the present case, the rights of the deceased people were violated under Article 14, 19, and 21. And
But
also,
which
Your
powers
Lordship,
are wider? Are you aware? Is it Article 226 or Article 32?
Your Lordship, it is Article 226. But
Why?
Your Lordship, because it also gives a violation of fundamental rights as well as legal rights, Your Lordship.
Okay.
Yes. Please
If Your
continue.
Lordship says, oh, yes, Your Lordship. Your Lordship, it is humbly submitted that in the case of Om Prakash versus State of Jharkhand, 2012 SC 604, it was stated that extrajudicial killings are not legal under our criminal justice administration system and are equated to state-sponsored terrorism. Your Lordship, here the state had authorized the police to use force, which does not only give them the discretion of choosing what type of force to use, but also how to use it. Your Lordship, without giving the petitioners a chance to be heard, the police officers had taken the discretion and deciding that these people were leading violent mobs and directly shot them dead. Your Lordship, it is also humbly submitted that in the case of Babulal Pate versus State of Maharashtra, AIR 1961 SC 884, it was held that the right of the citizen to hold public meeting is enshrined under Article 19(1)(b) and to assemble peaceably without arms. Hence, the state cannot impose unreasonable restrictions on such assemblies. Your Lordship, even after the imposition of a curfew, the citizens do have a right to enjoy their exercise of Article 19(1)(b), and they were conforming to the same without the use of any arms or creating any havoc or violence. Your Lordship, it is also stated that in the case of Hemant Lal versus Police Commissioner, 1973 AIR 87, it was stated that the state could make regulations to aid the right of assembly. Reasonable restrictions can be imposed, but no rule could be prescribed prohibiting all the assemblies altogether. Your Lordship, it is humbly submitted before your honorable bench that in the present case, the state had imposed a curfew, and this curfew was followed by the petitioners, and they had not violated any of these under the said order. But Your Lordship, the police officers had taken unduly advantage, acting beyond the law bounds of authority, and they had committed a grave offense of encountering these people without giving them a chance to be heard. Your Lordship, in the case of Maneka Gandhi versus Union of India, it was stated that the procedure prescribed under Article 21 needs to be reasonable, just, and fair. Your Lordship, in the
Do you
present
think that
situation,
judgments have to be applied considering facts of the case? What are the facts in this case and what were the facts in the case of Maneka Gandhi?
Your Lordship, in the case of Maneka Gandhi versus Union of India, Maneka Gandhi had applied for her passport and she had received it, but then she was asked to submit her passport, which had violated the rights under Article
So
21
here there
under
was
personal
some
liberty.
extraordinary measures which were required to be taken. So how does that ratio apply in facts of present case?
Your Lordship, in that case, the Supreme Court had laid down the Indian version of due process of law, which has stated that the procedure to be followed under Article 21 should be fair, just, and reasonable, which is a very important connotation in our present case, Your Lordship. Because, Your Lordship, the procedure that the police had applied was not fair, it was not just, and it was not reasonable.
Okay, so that's the ratio which you are trying to rely on.
Yes, Your Lordship. Your Lordship, moving on to the case of K.S. Puttaswamy versus Union of India, 2017 10 SCC 1, it was stated that there should be a rational nexus between the object and the means adopted to achieve them. Your Lordship, in the present case, the objective of the state was to maintain public order and bring back the order to the public by allowing police to use force. But Your Lordship, the actions taken by the police had done exactly the opposite. They had created a violent environment between the public where public cannot trust the law enforcement agency, neither they could have trusted the state authority because police were carrying out encounter operations based on their discretion. If your lordships are satisfied with issue 1, the council seeks permission to move with issue 2.
Since you have limited time, you can go to the second issue.
Much obliged, your lordship. Your lordship, the issue 2 deals with whether the invocation of section 144 of CRPC and the subsequent use of lethal force by the police was justified under the present circumstances, or did they constitute of abuse of power? Your lordship, it is humbly submitted that the invocation of section 144 and the lethal use of police had grossly violated the fundamental rights of the people and cannot be justified in the
Who
present.
invokes section 144 of CRPC?
Yes, your lordship.
Section 144 is invoked by whom? Of
The state had
CRPC?
invoked it, your lordship.
But
And
is
your
it
lord,
justiciable? Is it a justiciable issue whether the state could have invoked section 144 or not? The police commissioner has been given the discretion to exercise the powers under section 144 whenever maintenance of public peace and order is required, correct? So
Yes, your
whether the Supreme Court can sit in appeal over the discretionary exercise of the discretionary power by the commissioner under section 144.
Your lordship, it is most humbly submitted that under section 144, the procedure to invoke section 144 is mentioned, where the state or the magistrate has to invoke by written order under section 134, stating that such an action has been taken place. And your lordship, in the present case, the petitioners are stating that the procedure that was followed to invoke section 144, it cannot be justified because use of force and violence on the part of police was wrong, your lordship.
That is the subsequent stage. Section 144 was that restriction was imposed. In spite of that section 144, there was a procession, correct?
Your lordship, after the procession had taken place, then section 144 was imposed.
Okay, so but then that there was a violation of section 144 when these 5 young people went out, were found on the streets. That was in violation of section 144.
Your lordship, it is most humbly submitted that there was no violation of section 144 because the state had imposed a curfew, but these 5 people were not together at the present, which was also stated in the clarification that we cannot assume that these 5 people were together at the same point at the same time, and they were not creating unlawful assembly or causing any protest. Your lordship, these people were simply exercising their rights under Article 19(1)(b), your lordships.
Were they not leading the mob?
Been alleged by the police, but it had not been proven because before the proceedings could have taken place, these people were encountered.
Yes, have you produced the affidavits of the eyewitnesses? That is what you're saying?
Your lordships, the affidavit has not been taken by the eyewitnesses because the police had failed to follow the procedure that was mentioned in the guidelines, which stated that after an encounter has taken place, the police needs to take the witnesses, the earth evidence, and every other evidence that was present at the scene, your lordship.
Okay. Yes, please continue.
Much obliged, your lordship.
Your 20
Your lordship-
minutes are over, just to inform you.
Your 20 minutes are over, so you are going to argue for 30 minutes, no?
Your lordship, speaker 1 has reserved 20 minutes. The council seeks permission and extension of 2 minutes to sum up issue number 2.
Okay. All right.
Much obliged,
Yes,
your lordship. Your lordship, issue number 2, in the case of Rajasthan State Electricity Board versus Mohan Lal, it was held that all actions of the state was authorized, even those undertaken during emergencies, must conform with the constitutional principles, which in the present case they have not, it has been substantiated in the previous issue. Your Lordship, it is also stated that in the case of Kartar Singh versus State of Punjab, when the police had conducted the encounter and executed 5 innocent civilians on the spot, they were deprived their right to be informed of the charges and the opportunity to be heard, which has grossly violated the fundamental right as it is in the present case, Your Lordship. Your Lordship, also in the case of Extrajudicial Execution Victims Family Association versus Union of India, it was held that policemen forces killed to justify custodial deaths and fake encounters, or what this court has called administrative liquidation, is simply not permitted by the Constitution, Your Lordship. Your Lordship, in the present case, the absence of accountability of these encounters represent a grave failure to uphold the rule of law, and allowing these actions of the police to go unchecked will undermine the public trust in the law enforcement and the judicial system. Your Lordship, it is most humbly submitted that the police in this present situation has assumed multiple roles. They are not only the accuser,
Don't you
but also
think
the
that the arguments which we are making, as far as facts are concerned, the violent mob which was there, the ruckus which was created, so invocation of 144, how can you challenge it? How can we sit in appeal over that?
Your Lordship, the violent mob
How
that
do you
had taken-
interlink these two issues? 144 and then subsequent lethal action by police. How these two can be interlinked?
Your Lordship, it is most humbly submitted that in the moot proposition, it was stated that when the violent protests had broken out, the state had imposed Section 144. And after imposition of 144, the police had carried out a series of encounter operations, Your Lordship. Your Lordship, it is most humbly submitted that these 5 men were nowhere stated to be a part of these violent protests, and it does not justify the police's action to encounter them directly.
So are you trying to mold your prayer by saying that 144 may be justified, but subsequent action still is not justified by police?
Your Lordship, the method used to invoke Section 144 was not justified, Your Lordship.
Okay.
Much obliged, Your Lordship.
Yes.
The Lordship, it is further humbly submitted that the police officers had assumed multiple roles in the present situation, where they are not only the accuser, but also the prosecutor, the judge, and the executioner. If Your Lordships are satisfied with issue number 2, the council would like to engage the second speaker.
Since it is the turn of the next speaker, next motor, please, yes, the next
Much
council.
obliged, Your Lordship.
Just please.
The council seeks permission to begin with issue number 3.
Yes,
Whether the
please.
police officers involved should be held accountable for the alleged extrajudicial killings, and what standard of proof should be applied in such cases. It is most humbly submitted that the police officers are liable under Part 3 of the Constitution and should be held accountable. It is respectfully submitted that the police officers involved in the alleged extrajudicial killings, they have violated the right to life and personal liberty, and it is a sacrosanct to the lives of the
Once
people.
you are saying alleged extrajudicial killings, so first of all, it has to be established that these are extrajudicial killings. How do you establish that?
Your Lordship, in the present case, it has been mentioned the year that the extrajudicial killing has taken place is the year 2022. Right now it is 2024. The proper procedure and the guidelines which have been provided in the PUCL versus State of Maharashtra has not been followed, due to which is why we have issued a writ of mandamus, the writ of under Article 32, in order to get the remedies that we are supposed to get, which have not been followed due to the not following of the due process of law and the procedure established by the law, due to the mishandling of the lethal force used by the police officers.
You mean to say that you have prayed for a writ of mandamus? You said you have issued writ of mandamus.
We are praying for a issue of mandamus, writ of mandamus, to issue a direction for an independent agency to inquire into the matters of the encounter, that has been followed in according to the guidelines of the PUCL versus State of Maharashtra.
Okay, yes. So your prayer is limited to appointment of a investigating agency or a judicial commission for inquiring into the cause of death of these 5 persons? What is the relief that you are seeking? The prayer? What is the prayer in your memorial.
Your Lordship, the prayer that we would like to invoke is to uphold that the encounters by the police has violated the fundamental rights of the deceased, to uphold that the invocation of Section 144 of CRPC and the lethal force used by the police constitute an abuse of power, to hold the police accountable for the extrajudicial killings and order criminal proceeding against them as per the guidelines that has been put forward, and to provide compensation to the dependents of the deceased, and to last to invoke a writ of mandamus and direct the state to start an independent investigation headed by the former justice to inquire into the encounter cases, as has been mentioned and justified in the case of PUCL versus State of Maharashtra.
So for praying for writ of mandamus, have you followed the prerequisite, the precondition? Are you aware what's the requirement before praying for a writ of mandamus?
Yes, Your Lordship.
The query is, have you made any representation to the government, state government, for appointing such a commission or for making any inquiry? Or you are straight away simply coming to the court without making any such representation to the government?
Your Lordship, there has been no representation as such because there has been no procedure, no procedure has been followed, and no right or remedies have been provided to the petitioners as such. We do not have a chance to represent towards the government, because of which we have applied or invoked this particular writ.
Would you like to approach the authorities and withdraw this petition?
No, Your Lordship.
Okay, you can proceed in your own way.
Good, you are holding your ground. Yes.
Yes.
It is most respectfully humbly submitted that the due process of law has not been followed in this particular case, as has been mentioned and iterated in the case of Menaka Gandhi versus Union of India, asserting that any deprivation of life or liberty must adhere to reasonable, fair and just process. In this instance, the police failed to conduct any inquiry or provide due notice before executing their actions, violating the fundamental rights enshrined under Article 21 of the Constitution. Furthermore, the procedural safeguards under Section 129 of the CRPC were disregarded. The police did not issue prior warnings or follow prescribed procedures before resorting to force. The actions also contravene to the Section 176 of the CRPC, which mandates an executive magistrate's inquiry into cases of alleged extrajudicial killings. This failure to observe legal requirements renders their action not only arbitrary but also not constitutional. If Your Lordships are satisfied with issue number 3, I would like to move forward with issue number 4. Whether the state government's actions in defending the police encounters can be justified in the interest of maintaining public order, or if they undermine the rule of law and constitutional protection. It is most humbly submitted to address the grave issue of police accountability in light of the extrajudicial killings. These killings, reportedly conducted under the guise of encounter operation, represent a fundamental breach of constitutional guarantees, especially the right to life and personal liberty under Article 21 of our Constitution. It is most humbly submitted that it must be emphasized that the police actions in this case blatantly disregard procedural safeguards and legal parameters. The landmark judgment of Om Prakash and others was the state of Jharkhand explicitly held that extrajudicial killings have no place within the framework of our criminal justice system, equating such actions to state-sponsored terrorism. The duty of law enforcement is to arrest, not to kill. The present case, where 5 unarmed individuals were deprived of their opportunity to defend themselves, starkly violates this principle. The police exceeded their legal authority, acting unilaterally and without procedural safeguards, leading to a loss of innocent lives. It is
Counsel, if the police officers were acting in self-defense or to protect the people at large, if during the course of that action, if the accused got injured or got killed, can the state not try to defend them, to at least find out till it is established that the police officers had acted unjustifiedly or that they had used unreasonable force? At least till that finding is given, Can the state not defend the police officers? Otherwise, the entire police force in the state will be demoralized, no? If the state says that, no, we will not defend you because some allegations are made against you.
In this particular case, the five people who were extrajudicially killed, they were unarmed. They were unarmed, innocent civilians. And in this particular case, the police authorities, they had the force, they had the authority for a force that is defined in section 349. They do not have the force that is applied to an extent that can take the life of another person. It is the duty of the state to protect its civilians. According to the Parents Patria, the state is the guardian of its people. Whether the own guardian of the people is the one killing, it's not proportionate to kill the innocent bystanders who might have been in part of the protest, because right notification under 144 through 134 of CRPC has not been issued. So why the lives of the innocent bystanders should not be compromised to the extent saying that the defense of self-defense under section 96 and 96 of IPC and 46 of CRPC can be taken.
Yes, please continue.
Go on.
Now, furthermore, it is humbly submitted that the rule of law forms the cornerstone of a constitutional framework and as an essential part of the basic structure as enunciated in the case of Keshavananda Bharati judgment. The extrajudicial killings conducted without adherence to due process or procedural fairness exemplify such arbitrariness. Article 14, which guarantees equality before law, has been grossly violated as these men were deprived of their rights without a fair trial or due inquiry. If your lordships may look at the memorial, page 33, para 52, the trend of encounter killings, as evidenced by the National Crime Reports Bureau data, reveals a systematic misuse of police power, reflecting a troubling normalization of such extrajudicial practices. Inspector General Rakesh Singh's operation, allegedly targeting unarmed civilians without prior authorization or warning, exemplify the systematic failure, further eroding public trust in the rule of law. It is not the prerogative of the police to decide guilt or mete out punishment. Only the judiciary has this authority, and only deviation from this established legal process strikes at the very heart of the democracy and the rule of law. If your lordships are satisfied with issue number 4, the council would like to move forward with issue number 5.
Please go ahead.
What remedies, if any, should be granted to the petitioners if the Supreme Court finds that the actions of the police and state government were unconstitutional? It is humbly submitted that the Constitution unequivocally guarantees the right to judicial remedy under Article 32, empowering citizens to seek enforcement of their fundamental rights directly before this Honorable Supreme Court. The petition is a rightful invocation of such remedy arising from the blatant violation of Articles 14, 19, and 21 due to the unlawful and extrajudicial actions of the state actors. This will be substantiated in a twofold manner, that is the absence of adequate alternative remedy and the remedies under Article 32. It is submitted that the Article 32, being a fundamental right itself, serves as the cornerstone of the constitutional framework. In the case of Neelabati Behera versus State of Orissa, this Honorable Court held that the state bears liability for the deaths that have been caused by the state. To prevent arbitrary actions by its officials, the killings in this case, devoid of any evidence of immediate threat from the victims, unequivocally constitute unlawful death. It is humbly submitted that the guidelines provided by the PUCL was a State of Maharashtra case has not been adhered to, such as there have been no magisterial probe. A mandatory inquiry into the cases of encountered deaths must be held, and a report thereof must have been sent to the judicial magistrate. An independent probe, that is an investigation into the death, must be done, wherein it has to fulfill the minimum investigation requirements like identify the victim, recover the evidences, preserve evidentiary materials, and so on, has not been followed. Amounting to an offense, anything that is amounting to an offense under the IPC, disciplinary action must be initiated against the police officer found guilty of wrongful encounter, and for the time that officer must be suspended. the compensation scheme, which has been described under Section 357A of the CRPC, must be applied for granting compensation to the dependents of the victims. The court in the case of PUCL versus State of Maharashtra directed that these requirements must be strictly observed in all cases of death and grievous injury in police encounters by treating them as law declared under Article 141 of the Indian Constitution.
Yes, please.
With this, the arguments and the issues have been summed up.
How do we arrive at the quantum of compensation?
Mhm.
The quantum of compensation can be arrived at if you were under the section 357 of the 357A of the CRPC, and it has been given a clause wherein the district legal
This is authority.
authority, and they are the ones who will be finding the quantum of compensation which is to be given to the victims, the dependents of the victims or the deceased.
But when they decide that quantum, how will they decide the quantum? Will they have to hear you and the state government, or they will decide it on their own?
The district state legal authority, they have their own authorities in which they will go and investigate into the matters of where the case where the issue had, and they will go into the different victims, and they will inquire into all of this and collect the evidence, and then assess the amount that has to be given as a compensation.
So that should be submitted as a report to this court. That is what you are
Yes.
suggesting?
Yes, your lordship.
Okay. All right.
With this, I would like to move forward to the prayer of the petitioners.
Yes, please.
Therefore, in the light of issues raised, arguments advanced, and authority cited, may this honorable court be pleased to adjudge and to uphold that the encounters where the police has violated the fundamental rights of the deceased, to uphold that the invocation of Section 144 of the CRPC and the lethal force used by the police constitutes abuse of power, to hold the police accountable for the extrajudicial killings and order criminal proceeding against them as per the law, declare compensation for the families of the deceased for their loss, and issue a writ of mandamus and direct the state to start an independent investigation to inquire into the encounters and cases, and or pass any other order as it may deem fit in the interest of justice, equity, and good conscience, all of which is most humbly and respectfully submitted.
All right. We'll consider after we hear the other side.
Yes, your lordship, much obliged.
Okay.
Thank you.
Thank you. Before the other side commences, shall we have a 2 minutes break or a short break?
Yeah, sir, we can take, sir. Yeah, sir.
Okay, yeah. So we'll have a cup of tea and
Yeah,
then
sir. Definitely, sir. We will start resume after 3-4 minutes. Sir. Maybe
After
5
five.
minutes, sir. Yeah. 5.
Fine.
after 5 minutes.
Thank you.
Okay. What?
Thank you.
Yeah. So team code 10 will be starting after 5 minutes. The 4:45 we will resume. Thank you very much.
Yes, sir. Good evening. Yes.
Good evening.
Where are the respondents now?
Yes, sir.
Respondents
Respondents,
are ready?
yeah, they are ready, sir.
Respondents team is ready?
Yes, sir, they are ready.
Yes,
Go
counsel,
to-
you can start now.
May it please this honorable court, this is the counsel for respondent and the team code allotted to us is TC 010 and this is the motor one. Counsel seeks
Okay.
permission to collectively refer the bench as your lordships.
Okay, yes, please.
Much obliged, your lordship. With due permission of the bench, the counsel would like to state the jurisdiction of Honorable Supreme Court.
Respondents means you are for the state or for the concerned police officers?
For the state,
Okay.
Is there any counsel appearing for the police officers?
yes, both the counsel are clubbed together in this case.
Okay, all right. Okay, please start. Continue. Start your arguments, please.
Your Lordship, Article 32 of the Constitution of Republic of India grants every right to individual to move to Supreme Court for the enforcement of their fundamental rights, and the respondent reserve the right to challenge the same. If your Lordship is well versed with the facts of the case, the Council seeks permission to start with the opening arguments.
Yes.
We are here before this honorable court to examine the profound intersection of individual rights with the public safety in the Republic of India. The respondent submits that the state's action during the unrest in Prakaksha were not only legally justified but necessary to uphold the public order in some of the extraordinary circumstances. In the time of crisis, the state is charged with the dual responsibility of protecting its citizens and maintaining the constitutional order. The measures adopted, while extraordinary, align with the constitutional principle and statutory mandates. Your Lordship, the issue number 1 and 2 will be addressed by the main counsel, and the 3 and 4 will be addressed by my co-counsel.
Yes. Please
Your
continue.
Lordship, issue number 1 deals with the allegation of violation of Article 14, 19, and 21 of the Constitution. Your Lordship, the petitioner argue that the police action violated their fundamental right to equality under Article 14. However, Article 14 permits the reasonable classification based on the intelligible differentia, provided it has a rational nexus to the objective. The classification here was clear. It distinguished the violent protester from the peaceful civilians. The police action targeted the individual who were providing immediate threat as demonstrated by their active participation in the violence.
But for a threat, can police take away life?
Sir, it was a threat to a life, to the government property, vehicles, and all other stuffs which were burned during the protest.
There are
But
provisions.
could the officers not have arrested these 5 young people instead of just shooting them?
Your Lordship, the fact of the case is silent on the same, but it is a strong presumption. The mob were violent and they have the guns and other lethal weapons in their hand. And if police attempted to arrest with the few forces there, they might get injured and the public safety would be in danger.
Was any police officer injured?
Your Lordship, the fact is silent on this.
So you have not produced any medical certificates to show any injuries to the police officers
No, Your
caused by
Lordship.
these 5 persons, 5 young people.
No, Your Lordship, there is only a circumstantial evidence which shows that this was the scenario which was going on in the Prakaksha.
Yes. But have you asked yourself why the people have to approach the Supreme Court directly under Article 32? Because they have lost confidence in the police force. That if any complaint is filed against a police officer, it will not be properly investigated. So if they have lost confidence in the state, therefore they have to come to the Supreme Court and burden our file, no?
Yes, Your Lordship. Indeed, the petitioners who are Sarvesh Kumar and others, they themselves are not having belief on the police forces, and we are challenging the maintainability of these petitions.
State itself has formed various human rights commissions. The human rights are so important. The state also protects the human rights. So why are you defending such police officers who have taken law in their hands?
Police is the authority who have to maintain the law and order. And when the law and order is in danger, there are statutory provisions which give them right, and other provisions are there which in the self-defense and the public defense, police are empowered on their own discretion on the reasonable differentia. They can take such steps.
Go on.
Your Lordship, the police action has targeted the individual who has possessed the immediate threats, as demonstrated by their active participation in the violence. This classification was neither arbitrary nor discriminatory. It was a legitimate response to an extraordinary threat. Council would like to emphasize on the judgment of State of West Bengal versus Anwar Ali Sarkar, as mentioned on the page 12 of the PDF, para 2. That Article 14 allows differential treatment in the situation which demands it. The action of the police adhere to these principles, focusing on restoring the order while respecting the right of the innocent civilians. Further, Your Lordship, Article 19 guarantee freedom of such assembly, expression and association. However, these freedoms are not absolute and are subject to reasonable restriction under Article 19 Clause 2 to 4 in the interest of public order. The invocation of Section 144 CRPC during the violent protest was a necessary measure to prevent further deterioration of law and order. Referring to the ratio decidendi of the judgment of Ramlila Maidan incident versus Home Secretary Union of India in 2012, the Honorable Supreme Court of India has upheld the restrictions under Section 144 CRPC as reasonable and necessary to prevent the public disorder. Similarly, restriction in Prakaksha were proportionate response to the unrest and ensuring the safety to the larger populace. And now, Your Lordship, focusing on Article 12, which guarantee right to life and liberty, which permits deprivation of these
Article
rights.
12.
21.
21.
Oh.
Your Lordship.
No.
Which permits the deprivation of these rights according to procedure established by law. The police encounter were conducted under Section 96 to Section 106 of the IPC, which allow to use force in self-defense and public defense. Reference shall be made to the PDF page 19, para 25. At the decision of Darshan Singh versus State of Punjab in the year 2010, where the Supreme Court of India has recognized the right to private defense as extending to law enforcement during the violent threat. The petitioner also claims that the Article 21 was violated here, which are unsubstantiated as the actions were within the bounds of statutory and procedural safeguards, which is designed to address the imminent threat to the public safety. Now, with due permission of the bench, the council would like to proceed with issue number 2, that is justification of invocation of Section 144 and use.
Before you go to that, the counsel for the petitioners have relied upon the authorities to, this is not the first case of encounter. There have been previous cases of encounters, and there are judgments laid down, principles laid down by the Supreme Court in their judgments. So those guidelines have been followed by the authorities in this case. That is their grievance, that you did not follow the guidelines in this case.
Sir, Your Lordship, in the immediate
PUCL case, yes.
PUCL case is the guideline given by Honorable Supreme Court to be followed in the event of encounter cases, where there is procedures which should be followed after the encounter has been happened. The police have to maintain the diary and further inquiries, investigations, the examination of eyewitnesses. But in the event of immediate response to a threat, there is no such procedure which should be followed. It is on the rational judgment of the officer as the Inspector General who was in charge at that time.
Yes, you can go to the next issue.
Your much obliged, Your Lordship. Section 144 of the CRPC is a preventive provision invoked in the situation where the apprehension of danger to the public tranquility and safety. The violence that erupted in Prakaksha on April 10, 2022 escalated beyond a mere protest. Act of erosion, destruction of government property, attack on law and enforcement officers created a volatile environment and necessitated the immediate response. Your Lordship, counsel requests you to give the kind reference to the PDF page 16, para 16, at the case of Babulal Parathe versus State of Maharashtra. in which it is crystal clear to conclude that the section 144 of the CRPC is constitutionally valid and is designed precisely for emergency requiring urgent preventive action. Its invocation in the case was aimed at mitigating the risk possessed by the violent unrest and restoring the normalcy. The Honorable Indian Supreme Court, also in Madhulime versus Subdivisional Magistrate in 1970, emphasized that Section 144 of the CRPC serves as a powerful tool for preserving the public order and immediate threat to the present. The curfew imposed under the provision was measured response and carefully calibrated to prevent further escalation of the violence. Your Lordship, the respondent here humbly submit that the action were guided by the principle of necessity, proportionality, rooted in the legal provisions. Section 96 to 106 of the IPC, detail in the right of private defense, allows individual, including law enforcement bodies, to use force, including lethal force, in life-threatening situations. At last, Your Lordship, the Council would like to emphasize that the principle of necessity, which provide additional justification to the police action, under Section 81 of the IPC, actions taken to prevent greater harm are not offenses, even if they result in some harm. The violent unrest in the Prakaksha possessed a clear and present danger to the public safety, which necessitated the immediate and decisive measures. The doctrine of necessity is well established in the jurisprudence, supporting actions that aim to protect the public welfare in the extraordinary circumstances. Your Lordship,
But counsel, the fact that according to you, these 5 young people were indulging in violent activities, all 5 have died. I mean, that is why there is such a hue and cry. Suppose out of 5, one person was injured and he succumbed to the injuries, it is a different matter. The allegation is that you targeted all 5 and killed them. That is why the case has become a very serious one.
Without
And-
suffering a single injury.
Without showing any injury suffered by the police officer.
Your Lordship, regarding injury, the fact sheet is silent, and the killing of 5, encounter of the 5 men were necessary at that point of time to it was the least measures which was adopted by the Inspector General.
No, if you had suppose shot at only one person, the other 4 would have run away. But the fact that you shot all 5, it shows that it was a premeditated shooting by the police officers. Would it not show that?
In which
Prima
part of the
facie.
body were they shot at? Are you
Ah.
having any clarity on those facts?
Where were the bullets found?
No. So fact sheet is silent on the same.
Have
There
you
was
not done any fact-finding inquiry or something? Have you established an independent authority to inquire into these facts?
no, Your Lordship, no independent inquiry has been set up.
Then what they are saying has to be believed.
No, Your Lordship, as per the fact sheet, the mob was too violent, and the police step has killed only just 5 men at the mob who were escalating and who were leading the mob, getting more violent at that point of time.
They can be shot at the legs or some non-vital part of the body.
They might have been shot at the leg or the non-vital part.
Might have been, and something. This is something which is beyond court matters. Have to be decided on basis of evidence which is on record. You
Yes,
can't
sir.
argue that this may be there or this probably is there.
Yes, Your Lordship, these are the circumstantial evidences which could be corroborated with our claimings, but the fact sheet is silent, so we also cannot conclude on the same.
Okay, yes, you have anything else to add?
Yes, Your Lordship, lastly, the police and the state has acted on the constitutional parameters respecting all the provisions of constitution, and further the entire argument which is submitted by the petitioners, they had not established the case beyond reasonable doubt, and the police and they had not established that police has any wrongful intention or mens rea against the aforesaid persons. So this was all my submission from my end. Now, counsel seeks permission to allow my co-counsel to address the rest of the 2 issues.
Yes, please.
Much obliged, Your Lordship.
Yes, please.
This is mooted to for Team Code 10.
Yes, please.
The council seeks permission to address the 3rd issue.
Yes, please.
Your Lordship. Issue 3 raises the question on accountability of police officers for the alleged extrajudicial killings
You are appearing for whom? For the state or for the police officers?
for the state.
Okay. So
This-
nobody is appearing for the police officers, no? Huh.
Your Lordship, it is police and state combined.
Okay. All right. Then
All
you
right.
might have to do some little more answering if you are appearing for the police officers also.
I'm much obliged to do so, Lordship.
Okay. All right. Start, please.
Your Lordship, the petitioners allege that the actions of the police during the encounter operations constitute extrajudicial killings. The respondents, however, humbly submits that the police acted within the framework of the law, in good faith, and with the sole objective of restoring public safety during an extraordinary crisis. The measures taken were lawful, justified, and aligned with established statutory and constitutional safeguards. The law permits the use of force in situations where imminent threats to life and safety exist. Section 96 to 106 of the IPC provides the legal framework for private defense, including the use of lethal force. Section 100 IPC explicitly allows causing death if there is a reasonable apprehension of death or grievous hurt. In the present case, the violent mob posed an imminent threat with acts of arson, destruction of public property, and direct attacks on law enforcement officers. Your Lordship, Council requests your kind reference on page 19, para 25 of the memorial to the Honorable Indian Supreme Court in Supreme Court decision in Darshan Singh versus State of Punjab, where it was clarified that the right to private defense is activated by a reasonable apprehension of harm, even if no harm has yet occurred. The respondents humbly submit that the police, faced with armed agitators and widespread chaos, acted in accordance with principle to prevent further harm. Furthermore, Section 197 of the Criminal Procedure Code shields public servants from prosecution for acts performed in the discharge of their official duties.
Is a murder in discharge of official duty?
Yes, your Lordship. Encounter was in discharge of the extrajudicial killing.
Have the police produced any material to show the antecedents of these 5 young people who have unfortunately died? Did they have any criminal history? They seem to be from the college and in the nearby, residing in the nearby area. Why would they indulge in such a criminal activity that you had to kill them?
Much obliged, your Lordship, for the question. The people were suspicious as they were having violent and armed forces. They were causing mass destruction that resulted in the destruction of the public property. So it was an act of necessity that the police had to take at that very moment.
No,
And
the
the
question.
investigation has to be done on the same.
But were these people hardcore criminals?
That is the question.
The query of my Lord Justice Shah is what was the intention of this mob? Why were you aware why they had gathered?
And were they history cheaters?
The facts are silent on the same, but since they were suspicious on the same, and they might not be criminal at that very moment, but since they were causing mass destruction, so just to restore the public safety and public order, the act has to be taken. And as mentioned in the fact sheet, that they were leading to widespread violence, including torching of the government buildings and public vehicles.
So for that purpose, was their killing justified unless they had done something which had caused harm to the police officer or which was likely to take away the life of the concerned police officers?
Much obliged, Your Lordship, for the question. Beyond this life and safety of the police, the safety of the people, the citizens of the country was at stake. So it became the act of necessity, as correctly mentioned by the legal maxim, code necessitates non-habet legem, which means necessity has no law. So it was the heat of the moment that the police had to take such an action.
For that, they could have arrested them.
Arrested would not have created such an impact, since the people were actually involved into such a violent act that was destroying the public property and the buildings at large. The public safety was at stake.
You know
We
the
tried-
distinction. You know the distinction between law and order and public order.
Yes, Your Lordship.
Is there any distinction between law and order problem and a public order problem, or they mean the same thing?
The council seeks ignorance on the same.
Mhm. Okay, so there are Supreme Court judgments which lay down the distinction between law and order and public order. So in case of law and order, you see certain powers cannot be exercised, which can be exercised in public order. That is what we were trying to find out.
Yes,
Yes.
yes, Lordship.
Okay. Yes, please continue.
Much obliged, Your Lordship. Therefore, the respondents respectfully submit that the police officers acted lawfully and in good faith, adhering to their statutory duties. Far from being arbitrary, their actions were deliberate and proportionate response to the violent unrest, consistent with legal principles and this honorable court's jurisprudence. The council seeks permission to address the fourth issue.
Yes, please continue.
Much obliged, Your Lordship. The fourth issue deals with the concept of public order versus rule of law. Your Lordship, the petitioners contends that the actions of the state in defending the police encounters undermine the rule of law and constitutional protections. The respondents, however, humbly submits that the measures taken were essential to preserve public order, which is a foundational element of the rule of law itself. The Honorable Supreme Court of India has long distinguished between law and order and public and order. Referring to the case of Ram Manohar Lohia versus State of UP on PDF page 23, para 43 of the memorial, it is clarified that public order involves threats that disrupt social stability and the very fabric of governance. The violent protest in Prakasha, marked by arson, attacks on government buildings, and threats to civilian lives, posed a clear and present danger to public order as clearly mentioned on the fact sheet para 3. Further, Your Lordship, the invocation of Section 144 CRPC, which temporarily restricted certain fundamental freedoms, was a proportionate and necessary response to the extraordinary circumstances. The Honorable Supreme Court in Madhu Limai versus Subdivisional Magistrate upheld the preventive nature of Section 144 CRPC, affirming its role in addressing substantial and imminent threats to public tranquility. It is pertinent to mention that, Your Lordship, while the individual rights are integral to the Constitution, they are not absolute. The preservation of public order is a prerequisite for the exercise of these rights. As recently discussed in Amish Devgan versus Union of India, the Honorable Supreme Court is of the opinion that and reiterated that public order ensures the foundation upon which constitutional freedoms are built. The respondents humbly submits that
Earlier, you pleaded ignorance about this public order and ordinary law and order. But you are ready with all the judgments.
That is why I had asked you this question earlier when you were saying about damage to the public property, etc. So-
yes, Your Lordship,
So
I
have
did
you
mention-
understood the judgments, or are you only reading the paragraphs and citing the judgments?
I am relying on the judgments, Your Lordship.
Okay, okay.
Okay.
Okay, yes, please continue.
The respondents humbly submits that during the unrest, the priority was to restore stability and prevent further violence, which would enable the continued enjoyment of individual rights. At last, Your Lordship, the rule of law is not undermined by decisive action in times of crisis. On the contrary, the rule of law is preserved when the state fulfills its constitutional mandate to protect citizens and maintain order. The respondents respectfully submit that the police actions during the Prakasha unrest were lawful, justified, and conducted in good faith under the framework of statutory and constitutional provisions. The measures taken were not arbitrary, but were necessitated by the extraordinary circumstances to protect public order and prevent further harm, as relied on the maxim, quod necessitatis non habet legem, which is the necessity has no law. The Honorable Court is urged to uphold the legality and constitutionality of the respondents' action, recognizing their critical role in preserving public safety and societal stability during an unprecedented crisis. Now, Your Lordship, the Council requests for the permission to state the prayer.
As a
Yes.
respondent, do you have to make a prayer?
Yes, Your Lordship.
Okay.
What is the prayer?
The council seeks permission to rise for the prayer.
Yes.
Much obliged, Your Lordship. Your Lordship, in the light of the legal precedents, principles cited, and the provisions of the Constitution of Republic of India, applied and arguments advanced, the respondents most humbly prays before this honorable court that it may be pleased to adjust and declare that the actions of the state and its police force during the violent unrest in Prakasha be adjudged lawful, constitutional, and necessary for preserving public order. The police encounters did not violate Articles 14, 19, and 21 of the Constitution. The invocation of Section 144 CRPC and subsequent measures were proportionate and justified under the circumstances. Acknowledge that the state government's justification of the police encounter was in the interest of maintaining public order, preventing further violence, and ensuring the safety of citizens, and did not undermine the rule of law or constitutional protection, and or pass any order, direction, or relief that the Honorable Court may deem fit in the interest of justice, equity, and good conscience. Much obliged, Your Lordship.
Okay. So now the petitioners will give the rebuttal.
Yes, Your Lordship. The council seeks permission to proceed with the rebuttals.
Yes, please.
The council has three queries for the respondents. The first being, the respondents in the memorial have not asked to dismiss the present writ petition. Does it mean this means that do they disregard their whole case in this matter? The second question being, issue 5 have not been
Can you ask
addressed by
queries?
the questions that has been put forward in front of the court of law for the respondents. I apologize for the mistake. The issue 5 has not been addressed by the councils for the respondent, and can it be assumed that the respondents agreed to the remedies that the petitions have been prayed for in our 5th submission? And the third being, the council, the respondents in the arguments claim that this is an emergency situation, and then the encounter was the last measure they could have taken, but it is submitted, nothing else was done before to restore the public order.
Yes. Anything further?
So that is it, Your Lordship.
Yes.
Your Lordship, the council requests to make two more humble submissions for the rebuttal round.
Yes.
Firstly, the prayer in the prayer of the memorial, which we have submitted as a PDF, it is mentioned regarding the dismissal of the petition. And secondly, there is incorrect use of authorities in the petitioner's memorial, which is cited as Menka Gandhi versus Union of India. They invoke Menka Gandhi to argue that the right to life under Article 21 include due process, which they claim was violated by the police action. For the kind reference of the bench, Menka Gandhi case dealt with the confiscation of a passport and procedural fairness in the administrative action, which is not a life-threatening emergency. And secondly, the principle of due process in the Menka Gandhi cannot be equated on ground decision made by the police during the violent protest, where immediate action may be necessary.
Why did you not argue this in your reply? This is a rebuttal you are giving to their rebuttal. This is a rejoinder. You should have argued this in your reply. They had raised this in their initial arguments.
Your Lordship, we believe this should be argued in the rebuttal rounds.
Any proceed, please.
Yes.
And secondly, there is inapplicability of extrajudicial execution victim families association versus Union of India, which the case they have cited. In the argument, they argue that the extrajudicial killing in the case violate international obligations, citing extrajudicial execution of the victim families, which addresses a systematic extrajudicial killing in the conflict zones, particularly in Manipur, in the country like India. The present case involves a police action during the violent protest and not on a systematic policy of extrajudicial execution. The international obligations cited in extrajudicial execution of victim families are specific to conflicting zones like Manipur and do not apply to the law enforcement responses to the riots. Therefore, the petitioners incorrectly apply a conflict zone precedent to a public order situation, which weakens their arguments. And lastly, focusing on the Anuradha Basheen case, which is regarding the freedom of speech and expression in the context of internet shutdowns and not on the violent protests and public order. The principle of proportionality discussed in Anuradha Basheen case cannot be directly mapped to the operational discretion of the police under section 144, pointing out Anuradha Basheen, which deals with restriction on communication and not on the lethal force to the riot control. So therefore, it is submitted that opposing counsel should focus systematically to the court rather than highlighting wrong precedent to mislead the court. The counsel for the respondent rests their case.
Okay. Anything further? Okay, so do we close this case for arguments? Dr. Gupta?
Yes, I think we are done with on the both the sides. So we can have some remarks from your side and Sarvil sir also, and then Panthi sir also. Then we will have a marking, sir. Any
Okay.
info, yeah, for the future, not related to any.
No, but therefore
input.
we do the marking first and then make remarks, or first we make the remarks and then do the marking?
Yeah. So as you wish, sir, you can send the marks and then later on, maybe, sir.
I think that is better, no?
Marks we may
First.
send later.
Yeah.
We may, subject to lordships.
Yes, yes. So you are suggesting remarks first or the marks first, marking first?
I think he's suggesting the remarks first and marking can be shared later.
Remarks first. Okay. I would first request Mr. Sharvil Majmudar and Mr. Panthil Majmudar to offer their remarks, and then I will supplement. Yes, sir. Mr. Majmudar?
I think Sharvil Bhai's connection seems to be, there seems to be some
I
issue with
think
his
it's
connection.
frozen. So,
Yes.
Mr. Panthil Majmudar, you can start.
Yes, first of all, of course, I would like to thank Justice Mohit Shah for sparing so much time, and with his expertise and experience, I'm sure the remarks which he will share, they will go a long way for the future of these students. As far as I am concerned, all the teams, both the teams, I would first of all like to congratulate. Both were well prepared. And of course, as far as certain participants are concerned, on the judgments which they cited, I believe that they should always go through the facts of that case and then call out the ratio. And if the ratio is relevant, then only those judgments should be cited. So I feel that is something which you should learn, which I'm sure you will learn as you go on further during your career. Don't blindly cite judgments. Always concentrate on the facts. If the facts are silent on certain aspects, you can always have some effort to improvise by even having your own evidences in support. In fact, that can give you more opportunity to improvise or rather develop your case. And therefore, just once a query is put to you, one of the suggestions would be that you should not try to avoid a query or not plead complete ignorance, but try to the best of your ability to answer the query in such a way that the courts feel as if you have not tried to evade the query. Otherwise, all the participants, I believe, were very well as far as court manners are concerned, the decorum, etc., how it is to be maintained. All of them were very well aware of the same. And once again, I would like to congratulate all of them. Also, I would like to congratulate the Sambhav initiative for taking such initiative and organizing such moot court competition, which go a long way in future. I have also participated as a student in moot court competitions, which eventually do help us when we join the bar, because bookish knowledge is not something which is only going to come to your rescue. And it is the queries, the manner in which you answer those queries, the court mannerism. Sometimes you have to satisfy the judge on facts, on law, as well as the judge should not feel that you are trying to evade his queries. So these are all the arts of advocacy which you should learn. This would be my comments, my observations about all candidates. Of course, markings we will give. Otherwise, it is that all of them were quite well prepared, considering the stage at which they are right now in their student life.
I would like to just add one. My connection was a little weak. That for candidates, I share what Panthil Bhai Majmudar has said, and I would like to here acknowledge and thank my Lord Justice Shah for agreeing to grace the final moot court round. And as a lawyer and as a student, we have learned so many things from him, and even today we continue to learn. So it was our absolute privilege to be able to be here with your lordships. So
Thank you.
I would like to
Thank you.
thank your lordships.
Yes. Let me congratulate Sambhav Initiative and Ms. Hiranshi Shah for undertaking this wonderful exercise of organizing a moot court. In our days, when we were students, we did not have this benefit. And therefore, I envy you all young people that you get this experience even before getting your sanat. In fact, most of you start this from, I think, second or third year participating in the moot courts. So
Yes.
you are really very fortunate. That is why law has now become a very interesting profession, because it is not only confined to people who see lawyers in their families. Now they can, get the feel of the courts and arguments right in their college premises itself, college campus, without stepping out, even before stepping out. Secondly, you have much more exposure to internet and there's online information, which we did not get in our days. We had to go to a library and pick up a book to read any commentary on law. But then there is also a side effect of that we find that in law colleges, this running 5-year law courses, students are required to write articles right from the beginning, and then they do research, a lot of research on the internet. I believe that please don't rely only on the internet research. There are very standard textbooks on law. They lay down the basic principles. So you must also study those textbooks, like contract, law of contract, or law of property, or Indian Penal Code. Now you have the new Penal Code. There are many very good standard textbooks on these subjects. So you must learn these first principles from the textbooks also, and then do research on the internet or whatever other sources you have. Fortunately, now you also have the advantage of watching the proceedings of the Supreme Court and High Court, when they are hearing arguments. This opportunity was never available to us. In our student days, at the most, we would go to the district court and hear arguments in a civil or a criminal case. Of course, there were very interesting cases there also, but this advantage that you now have is unparalleled, and therefore, congratulations to all of you for studying law in this environment, such an enriching environment. Now, when you become lawyers, as I said at the outset, law is a very interesting and challenging profession. No two cases are alike, though they may be, having reference to the same law or the same section of the law, because the facts are different. And therefore, when one party relies on a judgment, the other party can always make an attempt to distinguish that judgment by pointing out that the facts are different. There are also judgments which lay down the principles on how to read judgments, the law of precedents, as it is known. So it is always very interesting to distinguish a judgment cited by the other side. It's a very challenging and interesting exercise, and it makes the legal profession a very interesting profession. Now, coming to the preparation for the facts of a case, my senior used to tell us that you try to read. Of course, I'm not referring to the facts of the case which you argued just now, because it was a constitutional case before the Supreme Court. But the cases which you will get when arguing cases before the district court or before the High Court or before the Supreme Court, there will be facts of the case which you will have to study very carefully. And after trying to understand the facts of the case, also taking proper instructions from the client. Mr. Majmudar, both Mr. Sharvil Majmudar and Mr. Panthil Majmudar will tell you that when the clients go to them for cases which are filed in the High Court, and they will ask the client, why did you not point this out before the district court or before the trial court? the client would say that, oh, our lawyer never asked us this question. So it's very important to know how to take instructions from the clients, because the client, when he comes to the lawyer, he's full of emotions, surcharged with the emotions against the other side. So you listen to the client, that is important. But at the same time, at some point of time, you will have to start making searching queries to the client, that why did you do this? Why did you not do this? I will just give you one example. I was a counsel for the state government. There was a solicitor's firm called Ambubhai and Devanji, and I was their standing counsel. They used to get cases, many varieties of cases. One variety was admissions to medical colleges. When there are admissions to the medical colleges during that month of July or August, there would be lots of cases filed against the government and the medical department and the medical college, why this student was given admission, why this student was not given admission. So a professor in charge of the admissions committee used to come to brief me. And the first time he came to me, he was very upset. Then after a few cases were argued by me, thereafter he acknowledged in a meeting that it was good that Mohit Shah asked me these questions. Initially, when Mr. Mohit Shah asked these questions to me, I was wondering whether he is our lawyer or the other side's lawyer. Because when your questions become searching questions, he finds it difficult to find out answers. But it is necessary that you should also know what are the points which the other side is likely to argue against you. So therefore, as a lawyer, you have to be ready to anticipate the arguments or the defenses of the other side, and be ready to meet with those arguments and defenses. A law, as I said, is interesting not only because you read it from the textbooks or from the case diaries, but also because it is connected with the society. Whether it is a criminal law or a civil law or a constitutional law, it deals with human beings. It deals with the situation in the society. So we have to be alive to what is happening in the society. Therefore, you must also be conversant with other branches of studies like social sciences, economics, political science, sociology. Even if you don't study them as formal subjects, there are many articles, good articles, which come in newspapers or other journals. So you must also read those articles and try to appreciate what is happening around you. Because sometimes as lawyers, you have to be very ready-witted and give answers on the basis of what is happening in the world around you. So wish you all the best. All of you are very good mooters, and therefore I have not given you any tips or clues on mooting, but all of you have done very well, and wish you all good luck. Thank you. Yes.
Thank you, sir. Thank you.
Now, can we break
Thank
for
you.
the
Yes,
markings?
Yes, sir.
Okay, so how do we do it? Because in presence of everyone, it will not be possible for us to discuss.
Yeah, Ishan, are you there? I request to take all three honorable judges in the breakout room.
Yes.
Yes.
Yes. That would be more convenient.
Yes. Charge the charger.
I request technical team to take honorable judges in the breakout room.
The host of the meeting will have to do it, I think.
Ishan, are you here in this meeting? Ishan, Yash?
Yes, ma'am.
Yes.
I think even
Please,
still the
take
participants are
honorable
here.
judges.
So, or if possible, the participants can leave and they can rejoin after a couple of minutes or 5 minutes.
in the breakout group, we should not be able to see the other participants, no?
Just a
So what we, yes, you rightly stated. Participants, you can leave for 10 minutes. We will send a message to you for rejoining.
Or can we do one thing, sir? We can by a conference call or something, we can discuss.
Correct.
We may put our mic and videos on mute.
No, or let
correct.
participants leave and rejoin. That is also okay. So
Okay, sure.
It is better only 3 of us are there.
Correct.
Yes.
okay.
Sure. Participant, please leave the meeting. We will inform you when to join, and other participants also. We drop the message in the chat box in group. Thank you.
is sending you in the breakout room. Just a 1 minute. Pantil sir, you are on mute.
Yeah, I was on the call. So we have already
Okay.
discussed. I think now there is no
Okay.
need of a breakout room.
Okay, sir. Okay, sir.
So the marks we are required to share with whom?
Sir, you just update in the score sheet. So we are able to see the marks.
No, but score sheet here. How do I update? I have to update here.
Uh, uh, just a minute, sir. Ishan, are you here?
Ma'am,
Ishan or Yash?
yes, ma'am, I'm here.
Yeah. Kindly take back the
Ma'am,
Sharvil sir
excuse
and
me,
we are
your
in the
voice is
breakout room.
cracking. Huh, ma'am?
Kindly take back the Sharvil sir and Justice Mohit Shah sir in this main room. They was in the breakout room.
Okay, so we have to make a new breakout room.
No, you
No,
need to bring them back here.
he is already in
Ma'am,
Bring
done.
them back here.
Done,
the
done, done.
breakout room. You have to take his mainly.
They'll be back in there. So time was set up, so they'll be back in 10 seconds. Mohit sir and Service sir will be back in 10.
00 આવે છે. Oh, sorry.
Sir,
We are in the breakaway group or
no, sir. Now
Now
there is
sir,
a
now
in the
you have
main.
now joined? Okay, okay.
Yes, sir.
All right.
All participating teams and especially the finalists, the time is come to declare the result for the winner of second online national food court competition 2024 and also the best mooter and best researcher. So I request to the Justice Mohit Shah sir and partners of the Majmudar firm to kindly declare the result. Sir, I had sent you the team
Okay,
code.
only 1 minute.
We are from
The prizes are for best team, then best mooter.
and best researcher.
for researcher also.
Yes, sir. We had conducted the test
Yes.
based on the MCQ and I
So there are only 3 prizes, correct?
had sent
Okay.
you the name as well.
Okay.
Correct. So I will send my marks. Then Mr. Sharvil Majmudar is sending his marks. Mr. Panthil Majmudar is sending his marks. So then you will be doing the total, no, madam?
Sir,
Hiranshu?
total. Who is the
No, I understand.
Yes,
But
yes. What sir is suggesting is that all our individual marks we have sent to you. You will have to total it and then
of
inform
this,
sir.
second online national moot court competition? Yes.
so then you can send those marks to me and then I will make the announcement.
Sure. Sir.
ચાર્જર મૂકી દે ને ભાઈ જલ્દી. 19 છે ચાલશે ને?
So participants are tensed when the result will come.
મોકલી આપ્યું.
So wait for us some time. We have to collect the marks.
All are winners irrespective of result.
Yes, sir.
મેં આમાં ભર્યું છે સર. સર તમે નીકળી લિંક મોકલાવી ને WhatsApp.
I hope Miss Hiranshi Shah has the marks of all 3 of us. Hiranshi Ben?
Yes,
Okay,
sir. Yes, sir.
The respondents team, I'll declare the marks also or only the who are the winners?
Sir, your kind feedback and the winner.
No, no,
Sir,
I'm
your
sorry, I'm not able to hear you
feedback,
properly. Hello?
Not
Hello.
not
Sir,
the marks, only the names of winner and your feedback. That is what she said, sir.
Acha, okay.
Yes, sir.
Okay, okay, yes. The best team, I must congratulate both the teams. Both the teams did quite well. But since we have to select only one team, I would declare the petitioners team as the winner. And the petitioners team is, Madam?
Sir, KIT Law School, sir, Bhubaneswar.
Team
Ah,
4.
Team 004.
Team 004 KIT Law is from Delhi University.
Team 004
No, team 004 is not from Delhi.
The 004 from KIT Law School, and then respondent are
was
from Delhi University, sir.
Okay, acha. Oh, I see. So team 4 KIT Law is the petitioners are the winners. Petitioners team is the winner
KIT
as the best team.
Bhubaneswar.
There is a lot of disturbance in your voice,
Hiranshi.
Madam
Hiranshi.
Hiranshi. Okay. The sorry. Acha, KIT School of Law is from Bhubaneswar,
Yes,
right?
sir.
Congratulations to you.
Congratulations.
Thank you, sir.
Then the best mooter is mooter number 1 from the petitioner's side. Congratulations to you.
Thank you, sir.
Your good name, please.
So my name is Sakshi Singh.
Okay, very good. You argued very well. All of you argued well, but you argued better than the rest, all others. And the best researcher is also from the petitioner's side.
No.
The best research. Hello?
No,
No,
sir. I sent you the name of the best researcher and her university name also, sir.
No,
She's-
best researcher is decided by you or by us?
Sir, it's decided based on the MCQ test is taken by us.
Academic.
So whosoever
So that is
secured the
your
highest mark- Yes, sir.
Oh,
yes,
sorry.
sir.
That is your prerogative, correct?
Yes.
We were
Yes,
not
sir.
supposed to decide the researcher, correct?
Yes, sir. Yes, sir.
Okay, acha. So the best researcher is Ms. Sonika Kataria, North Cap University, Gurgaon.
Yes. Congratulations.
Yes,
to her.
Congratulations.
Congratulations.
Congratulations. Congratulations to all of you for participating in this moot court, and wish you good luck and best of luck for all future moot courts, and also more importantly in your practice as lawyers. And please do join as litigation lawyers, because these days a lot of law students, law graduates like to join the law firms. Of course, wherever you join, we are sure that all of you will do the best, and you will continue to contribute to the development of law, and see that as many people get justice as possible, and our legal system and justice system improves, and those improvements will come only from your side. Okay. Thank you. Wish you all the best.
Thank you.
Thank
Thank
you
you.
so
Thank you so much,
Thank you.
sir.
Thank you.
Thank you so much, sir, and thank you all the judges for judging this competition, and congratulations to winner. I just make a last announcement that the winning team will get an internship opportunity with the former judge of High Court, along with internship opportunity to our distinguished judges legal firm, that is S&P Majmudar Associate, along with the cash prize of 5,000 rupees and the trophy. Congratulations winners, and also the runner-up team will get internship opportunity with advocate on record of the Supreme Court of India, along with internship opportunity at S&P Majmudar Associates, and the cash prize worth rupees 4,000 and trophy. Congratulations to the runner-up team as well, and also the best mooter will get internship opportunity with former judge of Supreme Court of India, along with the cash prize of 2,000 rupees, and the another internship opportunity with S&P Majmudar Associates, the team, and the base mooter and the base researcher. Thank you, everyone.
And the participants are also welcome to join any retired judge doing arbitration, because arbitrators also require a lot of assistance. Just as senior counsel requires assistance, just as judges require researchers, we also require researchers and good law assistance. Okay.
Thank you so much,
Thank
sir.
you, sir.
And
Thank you,
lastly,
sir.
I
Thank
also
you.
would like to again thank to the SNP Majmudar sir, especially Panthil sir and Charvil sir, to supporting this competition and make it happening due to your support. Thank you so much, sir.
Okay. Thank you.
Thank you,
Thank you.
everyone.
Thank you. Thank you. Thank you. Thank you, Dr. Gupta. Thank you,
Yeah, thank
Hiranshi.
you. Welcome, sir. Thank you.
Thank you.